Ready, Tabitha. Are you ready?
Yep.
Good afternoon. This is the March 13, 2025 Washington Public Disclosure Commission brief adjudicative hearings. My name is Jay Leach. I'm the chair of the commission, and joining me is Commissioner Doug North. Before we get started with the first hearing, I'm going to ask Jennifer Hansen to give us a brief overview of the process and the criteria for the request we'll be considering. Jennifer, the floor is yours.
Thank you, Mr. Chair. The proceedings that we'll be hearing today are reporting modifications, and the Commission has the authority to grant a modification to any reporting obligation or requirement under its law. So under RCW 4217A or its rule WAC 390. And the process for that is that the requester submits an application for a modification to the reporting obligations, and staff brings that forward to either a full commission hearing or to a brief adjudicative proceeding as we're doing today. So the two cases we're hearing today have been provided the opportunity to participate and provide additional testimony, in addition to the written materials that have been provided to the chair and vice chair that are here today, and have also been made available to the public on the PDC website.
Thank you, Jennifer. Do you want to raise your right hand? Do you affirm under penalty of perjury under the laws of the state of Washington that all testimony you give shall be the truth?
I do.
Okay, we'll first consider the case of Mr. Leonard, and why don't you proceed?
Right. So this request was made by Kyle Leonard, who on February 24th, 2025, sent a request for redaction of information connected to a contribution that he made to the 2019 Egan Orion campaign. And Egan Orion was a City of Seattle City Council candidate in 2019. Mr. Leonard requested redaction of this information, indicating that that this information was made publicly available, specifically his address, and stated that he has taken steps to remove personal information from the internet and had concerns about his address being provided as part of the results in his internet search engine. Staff informed Mr. Leonard of the modification process, including that it would be necessary to receive consent from the Egan Orion campaign. On March 5th, 2025, staff received an email from Kyle Leonard that CC'd Egan Orion and confirmed consent to modify the Orion campaign reports per the commission's order if the request is granted. Mr. Leonard's records could be exempted from public disclosure if the commission finds, in accordance with RCW 4217A120 and WAC 390-28080, that the information would present a personal risk to a reasonable person. And so, as I mentioned, this is one contribution, $100, showing up on a report that was filed by the Egan Orion campaign. Mr. Leonard is here to provide any additional information that the chair and vice chair would like to have in order to consider this request. And I'm available for any questions.
Okay, Mr. Leonard, do you want to unmute your microphone and open your camera up, and we'll have an opportunity to hear from you. The first thing before you get started, two things. I'm going to have something to ask you to address if you have comments to make, and then I'm also going to have to put you under oath. The question I have is, we have a particular statute, RCW 42.17A.120, which requires us to find that having your information in our records prevents a manifestly unreasonable hardship in an individual case before we can grant the relief that you've asked. I'll let you know that your address is readily available on the internet in places other than the PDC records. I don't know if you're aware of that.
I've taken great pains to remove it from every other source on the internet, at least through Google searches.
Okay, well, you've been unsuccessful in another way, and I'll explain what that is, and then I'll put you under oath and let you testify, all right?
I may be able to guess it.
If you go to the King County Recorder's Records site and put your name in, the first document that pops up is a statutory warranty deed with your residence address on it. The second document is a deed of trust with your residence address on it. So anyone who is at all adept at looking for people would have no trouble finding you. So if you would raise your right hand, and do you affirm under penalty of perjury under the laws of the state of Washington that all testimony you give shall be the truth?
Yes.
Please tell us what you want to say.
Yeah. So I've taken pains to scrub my presence from Google, Bing, search engines like OpenAI. As you call out, information is still available if someone goes directly to the county auditor's website. The county auditor's website, though, sets flags in their meta headers that prevent Google from indexing their website, while the PDC disclosure documents do not. So for most people, when they go and do the search, most people are not adept, as I've learned working in tech. So scrubbing it from the internet, from search engines, mostly makes you invisible. Originally, when I started this, I worked in cybersecurity, and working at large companies like Google and Snowflake and being in cybersecurity, I was a constant target of spear phishing, where attackers would try to gain access to my accounts, both personal and work accounts. And having an address as a way of doing so, especially so readily available just via Google searches, I saw presented me a risk, especially my personal accounts, of being attacked. So that's what set me on the path here.
Okay, you didn't include in your statement that you'd been the subject of personal attacks. Could you tell us a little bit about that? Because that might be a basis for finding an individual hardship that.
Yeah. Okay. Yeah, I wasn't aware of the standard that the redaction.
That's fine. We're going to try and help you get there if you can.
Okay. Yeah. So I worked in cybersecurity, most recently at Snowflake, and my presence as an employee there would be known, and someone could potentially find my name on LinkedIn, which is unfortunately necessary for gainful employment nowadays. And then they would try to find phone number, address, information like that allows them to gain access to either my personal or my work accounts. Often by trying to guess passwords and then try to do things like SIM swaps, where they try to convince Verizon, my cell provider, to hand over my number, so then they can gain two-factor auth access to my accounts.
And did you actually experience those attack efforts?
I have not successfully. Luckily, Verizon is a bit more robust in recent years, and my employer also has. I worked in cybersecurity and threat detection, so we have threat detection capabilities to try to block such attacks.
Commissioner North, do you have any questions you'd like to ask?
I guess I would be interested, Mr. Leonard, where you've indicated in the past you've worked for cybersecurity folks. Is that what you're doing now, or is that just something you've done in the past?
I'm currently working for my own startup, adjacent to security, but not directly in cybersecurity.
Okay. See, typically the kinds of requests that we get like this for removing addresses are people who've experienced domestic violence, who've had people threatening them, something like that. And so, and it's those kinds of things that present a reasonable hardship that causes a basis for because otherwise the law was passed by the voters by initiative.
Mhm.
The voters want to know who's contributing to what campaigns, and that's what we're trying to make sure that we're carrying out the intent of the voters there.
Understood. I think, in all honesty, if I had been presented with the fact over email, like, can you with a straight face say that you're suffering like hardship comparable to like domestic violence or something like that, I'm like, I would not compare my case to something like that, in all honesty.
Okay. Okay, I'm prepared to rule, but I'm also going to make a request of you because you've told us something that maybe we need to explore as a commission. I'm going to deny your request because I don't think you've met the statutory standard, but you've talked about unlinking from Google and some other things. I don't know anything about that. Could you send the commission just an email if you have time to explain what you're talking about there and what's involved, so we can at least look at the issue? We may not agree with you and we may not be able to do it. Jennifer, I see your hand. I'll get to you. But I'd like to be a little more informed about that. And if you seem to be an expert in the area, if you could send us just an email to the commission, I'd appreciate that. And we can look at that. I don't know that it's appropriate for us to unlink, but I would at least like to understand what the issue is.
Yeah, I would absolutely love to. Could I give 15 seconds of brief input, or I can just send an email?
You can have 15 seconds.
Briefly, there's a little bit of information that web servers can set that tell Google, OpenAI, and other web crawlers, please do not index this page, which means it won't show up in Google search results.
Okay, very good. Thank you. Appreciate your time today.
Thank you very much.
Thanks. Jennifer, you had something you wanted to tell us.
Yes, I wanted to let you know that Mr. Leonard actually shared some of the information that he just shared verbally with me as part of his request. And I kind of put that on a different path than his actual request for the redaction today. So
very good. Appreciate that. And that's good initiative shown there, Jennifer.
Sorry for interrupting.
Go ahead.
Will send a follow-up email, Jennifer, with a bit more detailed information now that I know there's a possibility of someone seeing it. Thank you.
Well, we'll listen, so please do.
Will do. Thank you for your time.
Thank you. Tabitha, and then
Yes.
Ms. Tyak, we're going to hear your case now. Tabitha will present the case for the staff first, and then we'll give you an opportunity to present your side of your request. Tabitha, do you want to raise your right hand?
Yes.
Do you affirm under penalty of perjury under the laws of the state of Washington that all testimony you give shall be the truth?
I do. And I'm sorry, I'm just struggling with the settings for Ms. Tyak, so bear with me here.
I just saw her on the screen just a second ago, and then she disappeared again.
Tabitha, I made her a presenter. I can do that again.
No, she should have camera and mic abilities now.
I don't see a camera by her, so I'm going to make her a presenter again just so we don't have any technical difficulties. Is that okay?
Okay. And Ms. Tyak, can you just, to test it, unmute and turn your camera on to see if they work before we get started?
Yes, hello. This is Chanel
Perfect.
Tyak.
All right,
Hello.
so I'll make my presentation and then we'll get you sworn in.
Okay, thank you.
So this is a new partial modification request that was received from Chanel Tyak regarding the Simone Barron campaign. The request was received on February 19th, 2025. And this is a partial modification to redact information connected to a contribution she made to Simone Barron's campaign during the 2024 election year. This was disclosed pursuant to the filing requirements described in RCW 4217A 240. Ms. Tyack states that there are safety concerns regarding the address being publicly available, and that is in the packet that you received. Let's see. If this is approved, Ms. Tyack's records would be exempt from public disclosure if you deem that the records or find in accordance with RCW 4217A 120 and WAC 390-28080 that disclosure of such information would present a personal risk to a reasonable person. And Ms. Tyack is here and will give more information if you would like, and I am available for questions.
Thank you. Ms. Tyack, were you here and heard the last hearing we had?
No, I just
Okay.
came in about a few minutes ago. Yeah.
All right, then I didn't want to repeat something if you'd already heard it, but we have a statute that sets a standard that we have to follow. I'm going to tell you what it is, and then I'm going to put you under oath and ask you if you have some information in addition to what's in your email about the safety, privacy, and security concerns. The statute requires us to find that keeping your address in our records presents a manifestly unreasonable hardship in an individual case. The typical kinds of cases where we see that is if someone's been the victim of a stalker or of domestic violence or some similar type of situation. The last hearing we just had someone who was a cybersecurity person and wanted to keep his address secret because he was fearful of spear phishing and other kinds of attacks, but he didn't have any articulated individual hardship. So I'm going to put you under oath and then let you tell us what you have to say, okay?
Sure.
Do you affirm under penalty of perjury that all testimony you give in this proceeding shall be the truth?
Yes.
Go ahead.
Okay. Thank you for the opportunity. So it was brought to my attention just based on me doing a random Google search that my personal home address was made public without my knowledge or authorization. And it does make me a target. It puts me at risk as a single female living alone in an apartment where I have had cases of people, trying to identify where my location is. I'm a federal employee and there are certain risks involved, with having that information out there. It's one thing, if I'm a business or a corporation, or it's a business address, but if this is my residence, my private residence address, and it also tells how much I donated. So it also kind of makes me a target of, okay, this person has money, this person lives here. It's just an all around harmful situation to me, the private citizen. And I understand that there has to be a balance of protecting and adhering to the rights of the public for their knowledge's sake, and also the rights of the private citizen. Being a federal employee, we typically would, receive a Freedom of Information Act request. I believe it's a different statute for the state to release information. However, to have that just publicly out there now in cyberspace, essentially, we don't know who's used that information or where it's gone. And so the longer it sits out there, the longer essentially my information is at risk.
Have you had any specific instances of someone trying to locate you and cause you harm?
Yes, I have.
Could you tell us a little bit about that?
So I've had, relationships that didn't evolve as I would have imagined or wanted. And, as a result, it could be a spiteful, ex-partner, what have you. It could be somebody who's angry that we didn't endorse their campaign, because I'm also the chair of the Candidate Evaluation Committee. for King Pierce Farm Bureau, and candidates come to us for endorsement. And yeah, we've had, people that don't agree with our decisions. And so I have had, undesirable attention in that regard.
Okay. One thing I'm going to tell you is that Washington's public disclosure statute in terms of making information available isn't a lot different than there's an analogous federal statute. You don't need to make a FOIA request to find out who's contributed to federal campaigns. The amount you've contributed, your home address, and your occupation, if you've met a threshold, are all readily available. So Washington's statute parallels the federal statute. I don't know, you may not have been aware of that, but it isn't limited to someone actually making an affirmative request under federal law. It's simply out there in cyberspace as well. Commissioner North, do you have any questions you would like to ask?
I guess, Ms. Tyak, I don't know if you have the past incidents you've experienced. You referenced your work on an endorsement committee and so on. Were those concerns just targeted to the committee in general, or do you in particular? And has that actually happened on more than one occasion? I mean, I'm trying to get a sense of
Yeah.
What
So I'm the liaison, essentially. I'm basically I'm the point of contact for the committee as the chair. And, last year we interviewed 70 candidates for endorsement with Washington Farm Bureau. And we didn't endorse all the candidates. We didn't make a recommendation for endorsement of all the candidates that we interviewed. And so we do have candidates that come back and they come to me because I'm the chair. And so it does just kind of put that added risk out there that, okay, I can target this individual for whatever reason, whether it just be, I have the question or you didn't answer my email, I'm not saying that it's always harmful intent, but it's just a safety risk and a definite security concern that my address is out there, not even a post office box. This is where I live. And that's very concerning to me and also, like I said, I was not notified that this was going to be made public. It happened without my knowledge and without my consent. And I do feel that as a private citizen, I have certain protections that should be considered, regardless of what the statute may say. There's also protections and rights of the private citizen. It's one thing if I'm a business, a corporation, an entity of that nature, but I'm a private citizen, a single female living alone. It's just, I don't want that out there.
Okay, and you also indicated that you've had some experiences coming out of your personal life. Did any of those things ever rise to the level of anybody making a complaint or filing for harassment or a protection order or anything like that at all?
I mean, I could have pursued that had I wanted to escalate it, but I chose not to. And instead, I tried to handle the matter at the lowest level in my own hands, essentially, not answering the door, not picking up the phone, But yeah, I absolutely could have called 911 and escalated it. And maybe in some cases I should have.
Do you have anything further, Commissioner North?
I do not. Thank you.
Ms. Tyak, I'm going to find that you have not met the statutory standard that distinguishes you on an individualized basis. The concerns you've described are legitimate concerns, and I don't mean to minimize them, but any single woman living alone in an apartment who contributed money, I think would have the same risks that you have, and one that's also in the public life, like you are as chair of the Bureau Committee, has those risks, but that's not enough to satisfy what the statute requires. One thing I will tell you is our last witness, in his case, told us that there may be a way to unlink this information from a Google search, and we're going to explore that, which would make it a little more difficult to find your address. Someone would have to then go directly to the PDC records and make a search, and people may not have that same level of inquiry interest to do that. But you will get a written decision from us saying that we've denied your request. There are some review
Sorry.
remedies if you want to seek review of our decision.
I do, because I don't see the added value in having my home address publicized. If you must keep my first name and dollar amount, I could maybe consent to that, although I don't agree.
This
because I
isn't
think
a
someone can
question
make
of
a
consent.
request.
We're following a statute that we don't have the right to change or ignore. You've stated that you think that your individual rights trump the statute. We don't have the ability to do that. Perhaps a court of law will do that for you, but that's beyond the authority of our commission.
Yeah,
So
I think
thank
my
you.
personal safety should rise above a
I
level of,
understand your concerns, but
yes.
we
It's
didn't
very
write the law.
concerning.
So thank you for your time today.
And I can appeal this decision?
There is a process for doing it under what's called the Administrative Procedures Act.
Okay, I do
It's a
find
state
that if you
statute.
guys could be proactive about just notifying individuals that their information is going to be made public if they have any dealings with you, that could save and mitigate a lot of hearing time from the gentleman before me and myself. Like I said, I'm taking time off to be here to do this. It's a very inconvenient and very much a strain of resources.
Well, I
Oh.
heard your concerns and thank you for your time.
Thank you.
We have one person who wants to make public comment today. Before we hear from Mr. Edwards, I am going to make an announcement, and that as after today, the Public Disclosure Commission will not be entertaining public comment during the brief adjudicative proceeding calendars for several reasons. The first one of which is that the whole commission isn't at these hearings, so they're not hearing these comments. The second is that the purpose of these calendars is simply to resolve individual enforcement cases or requests for modification of records. So we don't think it's appropriate to have public comment in the future. But since we have Mr. Edwards here today, we will hear from him today.
And I'm just changing his settings. So there
And
we
here
go.
he is.
There he is.
All right. Well, thank you, Chair Leach and Vice Chair North. First, I wanted to thank you and the agency for hosting the stakeholder work group on Tuesday. Overhauling the reporting schedule is a great goal for the PDC, but as I think we all saw at that meeting, it is not going to be easy for everyone to find consensus on this issue. One thing that I think would help to build a consensus in the agency would be to take the feedback from Tuesday's meeting, discuss it, write up a more detailed proposal with an actual calendar showing us as treasurers when the reports would be due, and then release it for further discussion. Another thing that I'm hoping that the PDC would seriously consider is incorporating into your proposal the idea that was brought up by Commissioner North of merging C3 and C4 reports into a single report. Adopting this change would significantly streamline the reporting calendar, and it would also allow the agency to implement its successful automated reminder and notification system to all required campaign finance reports, which would also hopefully provide the same uptick in compliance that we saw over the last year. I would also point out that, this is how things are already done on the federal level, in California, in Alaska, in Idaho, and a number of other states. I don't have knowledge of all 50 states, but I'd bet money that most states use a single report for filing contributions and expenditures, and that the PDC is actually an outlier on this issue. But changing subjects, I wanted to speak quickly about enforcement and the factors that the agency considers when determining whether a complaint gets classified as minor and thus eligible for administrative dismissal without penalty. Looking at these factors has been something that has been on the agency's rulemaking agenda for longer than 6 months now. And I want to suggest that the only two factors that are relevant when determining whether or not administrative dismissal is appropriate are the scale of the violation and the degree to which the violation was genuinely outside of the control of the respondent due to medical issues, etc.
What do you mean by scale, Connor?
The scale of the violation, if a report is a day late or 2 days late, or if the report had $0 worth of activity, I think we could all identify that that's a de minimis violation, and that doesn't make sense to take to a hearing or try to get them to sign an SOU. But, if it's like the case I'm about to bring up, where the respondent failed to timely disclose over $500,000 worth of expenditures, the fact that they didn't know that that was the law is of virtually no importance to anyone outside of the PDC. They are using these factors to justify dismissal in order to avoid having to take cases to hearings. These are cases that in any other campaign finance jurisdiction would either go to a hearing or would result in a penalty via stipulation. So I agree with them. If it's a day or two late, if it has $0 worth of activity, dismiss away. But there are a lot of cases that are getting dismissed that don't meet that criteria. So the factors that I most contest are whether or not the violation was intentional. That shouldn't be a factor. Whether or not the respondent knew what the law required, and whether or not it was a first-time violation. If you look at other campaign finance agencies, and even if you look at other regulatory agencies more generally, what you will find is that practically no other agencies recognize the presence of these factors as justifying dismissal when the violation is non-de minimis. I'm also concerned that these factors are not being consistently applied, and I would point to the SEIU case that I just brought up, where a large, sophisticated PAC failed to timely disclose over $500,000 worth of activity. In the most lenient neighboring jurisdiction of Idaho, that would have resulted in a $1,300 penalty. In the most punitive jurisdiction of Oregon, neighboring us, that would have resulted in a penalty of over $40,000. But in our state, at the PDC, that exact same conduct resulted in an administrative dismissal. Beyond looking at how staff applied the factors in that case to reach that outcome, I think the dismissal raises the question of whether or not this agency knows how to conduct effective enforcement. I would argue that it does not, but I hope that this is something that the commission will eventually spend some time on. But that's all I've got. Thank you.
Thank you, and appreciate your participation on Tuesday.
Thank you.
I think that's everything we have. Kim, do you have anything else for us to deal with today?
No, nothing for me.
All right, then I think we're done. Thank you all for your assistance today. And this probably didn't tell you, Commissioner North, much about how this operates. But
well, it gives me a little idea.
yeah. And anybody have any quarrel with the way any of the cases were decided?
I'm
Tabitha.
sorry. Did you adjourn us?
I haven't yet. I'm finding out first if anybody has a quarrel
okay.
with any of the way any of the cases were decided today.
Did you want to stop the recording before we have the discussion, or
Yeah,
have
I
it on
will.
record?
I will adjourn the meeting